right is still right, even if you stand by yourself.
Chief Justice, may it please the court.
Welcome to this week's edition of Case in Point. Happy New Year. I'm your host, Sarah Parshall-Perry, a senior legal fellow here at the Heritage Foundation in Washington, D.C. It is Thursday, January 9th, and there are two cases set to be heard at the Supreme Court that will question whether or not online platforms, when they clash with the First Amendment, who will emerge victorious. In fact, in the first of those two cases, TikTok versus Garland, it's scheduled for Friday, which means we're going to hear oral arguments the day after you're hearing this podcast. What's at issue in that case? Well, a law was enacted and signed into law by President Biden in April of 2024. It was, and this is a mouthful, the Foreign Adversary Controlled Applications Act that identifies China and several other hostile nations as being foreign adversaries. What it does from there is ban those particular social media platforms that originate in those foreign adversary nations from being utilized in the United States. Well, who comes to mind first except TikTok and its parent company ByteDance, which are Chinese-owned corporations. So they've claimed that their inability to be able to provide an online platform here in the United States is a violation of the First Amendment. And, of course, the government has argued that this is simply just an ability, just the opportunity to protect American citizens from manipulative information from hostile nations outside American borders. Interestingly, the federal report on the judiciary, which is something authored by the Chief Justice of the Supreme Court, Chief Justice John Roberts, at the end of every year. And this one came out in December of 2024, around the same time that TikTok had made its emergency appeal to the Supreme Court after losing in the D.C. Circuit Court of Appeals. The Chief Justice penned his year-end report and published it, but might have actually tipped his hand on how he intends to rule in the TikTok case. Consider the year-end report on the judiciary, the essential state of the court's type of union address. That's exactly what the chief writes every single year. It's his assessment of what needs to be done differently in the federal judiciary, what the federal judiciary is struggling with, what the impacts are, what he sees as future challenges. And he addressed misinformation. In fact, his comment in particular about misinformation from abroad has to be read to be understood within the context of the TikTok case. So listen to this. The Chief Justice wrote, "Much more is needed and on a coordinated national scale, not only to counter traditional disinformation, but to confront new and growing concern from abroad. In recent years, hostile foreign state actors have accelerated their efforts to attack all branches of government, including the judiciary. In some instances, these outside agents feed false information into the marketplace of ideas, parentheses, possibly like online platforms. For example, bots distort judicial decisions using false or exaggerated narratives, and these actors distort our judicial system in a way that compromises the public's confidence in our process and outcomes." So did the chief, in your view, tip his hand on that type of misinformation from foreign adversaries from abroad in the TikTok case? Did he indicate how he was going to rule? Well, I guess only time and potentially Friday's oral arguments will tell. But there's another case on the docket that's scheduled to be heard only 5 short days later on January 15th. And that's the Free Speech Coalition versus Paxton case. This is a case concerning online porn providers. Yes, you heard that right. We've already talked about what a controversial term this is. Now we've got everything from Medicaid coverage to abortion to free speech rights, free exercise rights, online social media censorship, and now, yes, we have porn. Free Speech Coalition versus Paxton concerns the constitutionality of a state law originating out of the state of Texas that requires age verification for individuals to access online porn sites in the state. Well, porn sites are not your traditional free speech defenders. So this presents an interesting question. Can a state ban an individual without providing their age verification from accessing porn online? Can it do so to protect vulnerable minors? We've heard some talk already this term about the protection of vulnerable minors. We've heard oral arguments in the U.S. versus Scrimeti case. Remember, that is the gender medicine case that concerns the constitutionality of a state law banning access to certain medical procedures for minors who identify as transgender. That was a state law enacted to protect vulnerable minors. This, too, concerns a law enacted to protect vulnerable minors. So joining me today is one of our Heritage Foundation senior legal fellows, who is a colleague and a good friend of mine, Giancarlo Canaparo, who's recently written a piece on the fact that it's time for the Supreme Court to revisit what he's called the court's obscenity jurisprudence. When porn clashes with the First Amendment, who should win? That's on this week's edition of Case in Point. It's Thursday, January 9th, and my guest today is not only a senior legal fellow here at the Heritage Foundation in our Meese Legal Center, but also a good friend of mine, whip smart, probably smarter than me, although I would only ever admit that if he was in the room. It's Giancarlo Canaparo, and he's going to talk to us today. We're going to have a dialogue about the case that's already before the Supreme Court that will be heard in the next few days, Free Speech Coalition versus Paxton, which concerns...
Sarah, can I jump in?
Yes, please.
It's actually Giancarlo.
What did I say?
Gian.
Or
just John, like just Giancarlo, but it's not Gian.
Thank you.
You're welcome.
So I guess I did put the emphasis on the wrong part of that. Giancarlo.
Yes.
Okay, Giancarlo. Got it. All right, we're going to start over.
Okay.
Joining me on this week's edition of Case in Point is Giancarlo Canaparo, who is not just a senior legal fellow in the Meese Legal Center here at the Heritage Foundation, but also a good friend and a whip-smart lawyer. And we are going to talk today about Free Speech Coalition versus Paxton, a question concerning access to porn and the implications of the First Amendment, to be heard within a few days at the Supreme Court. Welcome, Giancarlo.
Thank you for having me, Sarah.
All right, so let's talk about this case. I teased it in the open to kind of let some of our viewers and listeners know exactly what's at stake. But talk to me a little bit about the facts of this case and then how we actually got to this point where it's before the Supreme Court.
Yes. So Texas passes a law that says if you operate a pornographic website, you have to verify that your users are over 18 years old. And the reason that the state legislature did this is because there's a body of research in social psychology that shows that pornography is deeply harmful to the human brain.
Yeah.
No matter what age or sex you are, mind you, but especially when you're a child going through pre-puberty and puberty. It's terrible for you. It creates all sorts of psychological problems, all sorts of relational problems.
Yeah.
Warps your idea of what a healthy sexual relationship is. So anyway, the state legislature said, look, if you're under 18, we have a certain duty as your state representatives to protect under 18 people. So if you're running one of these websites, you've got to verify age. You can do that in a number of ways, credit card verification. There's now a bunch of sort of third-party companies that can do this for you in other ways.
Okay.
But the state sort of did a balancing, right? It said, look, if you want to make this choice for yourself and you're an adult, okay, fine. But if you're a kid, no. So that's the law. And then we had a whole bunch of pornographic websites, at least one actress. Is that what you call them, pornographic actresses?
I suppose so.
That seems
in actresses?
A little bit. Moving along.
Guys, the show's never boring, okay?
So websites that host or in some way earn their revenue through pornography.
Okay.
They came together and created an organization called the Free Speech Coalition.
Not exactly the name
No?
I would give a coalition of those types of individuals.
But I just want your listeners to be aware that when you see free speech coalition, these are not, these are not, people fighting for free speech on campus.
No.
Or fighting against it. No, these are pornographers.
Yes,
and they
that's
found
exactly
themselves
it.
Now, actually, this coalition has existed for a while.
Okay.
They've won a Supreme Court case before. You might remember this. There was I believe it was a federal law. I could be wrong. I'm pretty sure it was a federal law that said if you use AI to generate child pornography where there aren't actually children involved,
right.
It's still illegal. And this coalition came in and sued and won and actually preserved the right, if you will, to create AI child pornography. So not exactly noble free speech warriors.
I was just going to say, not your typical free speech defenders, not somebody that we necessarily like seeing at the Supreme Court. We're going to get to exactly what the free speech right is vis-a-vis obscenity. We're going to talk about that in a second. But this to me, okay, so from a layperson's perspective, we've already heard oral arguments in the United States versus Scrimeti, right? So this is the ban coming out of the state of Tennessee that restricts certain medical procedures for minors based on gender identity, those sort of cross-sex hormones and puberty blockers and surgeries that are deemed catastrophic to minors going through this particular sort of gender identity crisis. The state's got a right to do that. You and I have written about it. We've talked about it before. Any power not reserved to Congress, to the federal government, is a state power, and medical licensing and the care of children are specifically those types of issues. Right. So this seems to be a fairly common sense, very easy analysis, right? A state can protect its children.
If
you don't think it's that easy.
If you are not a lawyer, this is an easy case.
Sure.
If you are a lawyer, this is a surprisingly difficult case. And the reason that it's a surprisingly difficult case is because the law is stupid.
Yes, it is, people. We're going to tell you very honestly, listen, we love the law. It is often very dumb.
I just mean, what I mean is not the law in general, not law in general. Law is a wonderful thing. I mean the Supreme Court's First Amendment obscenity jurisprudence is stupid.
Yeah.
You want me to, shall we just dive on in? Okay.
Please.
So let me introduce you to the sort of Wilsonian progressive vision of law, which is that there's a whole bunch of erudite experts sitting in Washington who just know how to run stuff.
Right.
And you people out in the provinces don't. And so we're going to do it ourselves. And this idea very much gripped the Supreme Court during the middle of the 1900s. The Supreme Court said, look, we have all these vast issues around here in the country, particularly like how do you regulate what's obscene? And they said, well, obviously you all can't do that. We're going to do that. And then so the Supreme Court says we get to decide what's obscene and therefore what's unprotected. But the Supreme Court realized, oh my God, that's an incredibly complicated thing to do, right?
Sure.
You've got community values that differ. You've got all sorts, thousands of different interests. And you have to now create, the Supreme Court says, well, we're going to create a one-size-fits-all approach for everybody. Well, if you're confronted with a question that big and that complex, what do? Well, you default to a sort of extreme libertarian position, which is just like everything is protected.
Right.
If it's, we just can't really figure out what is obscene and what isn't, what is pornography and what is art, right? And we're just, so everything, functionally, everything is protected, which means, it becomes very difficult for a state like Texas to say, well, actually, we have an interest in preventing this sort of harm from kids to kids. This is the only way we can really do it in this sort of ubiquitous world of internet pornography. So this is what we're going to do. And the Free Speech Coalition, the pornographers, I refuse to call them free speech.
Yes.
The Free Speech
Just
Coalition.
say pornographers.
They are pornographers.
It's more accurate.
They say, well, this is free speech, right? And where that gets, and from a legal standpoint, they're actually not, far off in terms of what the Supreme Court's jurisprudence is again.
Sure.
But where the case really comes down to this sort of the crux of the case, there's this older case called Ginsburg versus New York. And New York had a law that said if you're running a brick and mortar adult shop, right? You can have age verification, right? You can't sell pornography to a 16-year-old kid, right? You do have to make sure that they're 18. Well, so Texas says, well, this law is just,
Just like that.
Just like that, right? It just happens to be that, those stores don't exist anymore because of the internet. So that's where we're at. That's really where the crux of the case is. Is it really all about, like, is this actually some sort of free speech, or is this like, brick and mortar age verification? That's the crux of it. But because the Supreme Court's jurisprudence is this one-size-fits-all, protect all obscenity kind of approach, it actually makes it really hard for Texas to win.
Yeah.
I think there are ways that it could be done without changing the doctrine, but really I hope that the Supreme Court sort of steps back and says, okay, look, we've made a mess out of this. Let's step back and see if we can fix it. And it's not just messy because it's sort of just ridiculous to have a sort of one-size-fits-all super libertarian approach over a question of like profound moral import for people. Right?
Yeah, exactly.
Like this is a sort of quintessential democratic question because you've got to balance a couple things, right? You've got to balance the morality, which is just something judges can't do, right? This is what you have to do in your local communities. You balance these concerns about morality with concerns about, chilling free speech that runs close to the line, with how do you balance like research from social psychology that shows these are all really harmful things.
Yeah.
These are like, this is a juggling act, right? This is the sort of thing that has to be hashed out between, you and me in the town hall.
Yeah.
Can't be hashed out by 5 of 9 people sitting in a comfy marble palace in Washington.
Yeah.
But that's what the Supreme Court has done. So that doesn't make sense for that sort of prudential reason. It also doesn't make sense from the Constitution, right? Just go back to square one. First Amendment says Congress shall make no law abridging the freedom of speech, right?
Right.
So we're way far away from that. Supreme Court's jurisprudence doesn't even care what the freedom of speech meant, right?
Yeah.
But if you go back, you don't have to go back very far. These laws like this, like you said at the beginning, states have always had the interest in protecting people, particularly children, from these sorts of harms. Even in the early 1900s, you still saw courts upholding laws against blasphemy because blasphemy was contrary to public morality.
Right.
And the courts said that kind of question is for the democratic process. It's not for us.
Yeah.
But then comes along the Supreme Court and says, no, that's ours. And oh my gosh, that's a horribly hard question. So just forget it.
So let me ask you a question, because related to the democratic process, we saw in the earth-shattering Dobbs decision, Dobbs versus Jackson Women's Health, the democratic process played very significantly into the justices' thinking. They expressed the fact that the question of abortion should never have been taken up by the Supreme Court, but should be left to the people and their elected representatives. As somebody who watches the court like me, does that make you hopeful that they might actually say, okay, states can legislate on things like the age of an individual that can access pornography?
Actually, not very much in this case. And the reason is that in addition to the fact that the role of the democratic process played in the Dobbs decision, you also had the backdrop, which was that the right to abortion was created out of whole cloth, right? It didn't exist, doesn't exist. The right to free speech does.
Right.
Right. And the Supreme Court is supposed to be, in some way, right, the protector of that right. So if you are the free speech coalition, right, the pornographers, already you've made a brilliant first move, right, which is to frame yourself as the free speech defender. Yeah. So you have a right. There is a right which you have claimed, and it does exist, and you've claimed it. And that already puts you in a way better position than the federal government in Dobbs.
Yeah.
Because the right didn't exist. It has no constitutional basis. So the court is now sort of pulled in two directions. On the one hand, it wants to protect the democratic process, the balancing of morality and social science, right? But on the other hand, it hasn't been doing that for a long time. And it also feels like, well, as long as we are the ultimate arbiter of free speech, what could we really do besides a supreme libertarian position, right?
Yeah.
I mean, that kind of is, if you've made the first move, the second one almost has to follow. And you sort of, I wonder now, does the Supreme Court have the courage to go back to the Constitution and say, look, actually, there's a lot more room for people for state, local government officials to be regulating speech in the interests of like public morality.
Yeah.
But like you can't say public morality in the same sentence with law these days. Like
No, you can't,
no.
of course.
But that's the Constitution. That's the world the Constitution was dealing with.
Yeah.
And I don't know that the Supreme Court has the courage to go back to the path it never should have left.
Yeah. And you've talked a little bit, and I want to flesh this out, the sort of entirety of the Supreme Court's obscenity jurisprudence, right? So Ginsburg versus New York, you talked a little bit about how that was really, in a way, kind of the rectification of prior cases that were, widely libertarian, like protect it all. I'll know obscenity when I see it. So help build that basis for people who might not understand exactly why this case is so complicated and why Ginsburg doesn't actually solve the problem.
Yeah, so let me take you back to a case from the middle of 1900s called Jacobellis versus Ohio. Jacobellis versus Ohio holds that obscenity is not protected speech. So states can outlaw obscenity. Great, easy. That's not the hard question, though. The hard question is, what is obscenity? What are you outlawing? The Supreme Court fragmented, didn't reach a definition. And so, states couldn't really do anything. But that's the case which gives us that famous line from Justice Stewart Potter, right?
Right.
I can't figure out what an obscenity is, but
I know it when I see it.
Yes, exactly right. Well, fantastic. Like, what every state legislature is just supposed to read Justice Stewart Potter Stewart's mind. So failed. Fast forward a couple years, 1973, we get to Miller versus California, and the Supreme Court coalesces around a definition of obscenity, which is it's something which, according to contemporary community standards, appeals to the prurient interests, depicts sexual conduct in a patently offensive way, and lacks serious literary, artistic, political, or scientific value. That sounds like a great legal definition, but think about it for 1 second, and actually it's just, I know it when I see it.
Yeah.
Right?
Just with sort of more moving pieces.
Yes.
What are community standards?
Right.
What are prurient interests?
But more importantly, who decides?
Exactly.
Not state legislatures. It's the
Right.
justices still, right?
Right.
It's just 5 of 9 justices who get to decide what are the community standards. Well, whatever they are, I can promise you that the 9 people sitting across the street over there in the Marble Palace, their community standards are very different from
Yes.
somebody in a small town in rural Texas.
Right.
Or in Seattle. Maybe the same as Seattle. But,
For certain of the justices,
Right.
I would say yes.
But the point is that community standards are going to be wildly different wherever you are.
Sure.
But the Supreme Court has said, we are the community, and it's our standards that matter.
Right.
And that creates a huge problem, right? So you have to have a one-size-fits-all approach now. The only people whose opinion about balancing sort of morality and law and social science are 5 of 9 justices, a bare majority of the Supreme Court. But then you realize, actually, that's not what justices are meant to do. That's not what any judge is meant to do.
Exactly.
That's not what a judge can do. And that's not a decision that a judge reaches and imposes on the country by balancing his own sense of morality and justice and science is not one that is legitimate to anybody except him.
Exactly.
But those sorts of questions, those balancing questions, can only have legitimacy if they are the product of the give and take of the democratic process.
Exactly.
So you have a Supreme Court jurisprudence now, which is one size fits all, imposed on the top by 9 elite lawyers living in a marble palace. They don't live there, but
Basically.
yeah, right. Has legitimacy in the eyes of nobody and actually solves nobody's problems.
Yeah.
Right. And to boot, this is actually point number 1, but it's the cherry on top. It's unconstitutional to begin with. This is not the way the Constitution wanted these things resolved.
That's exactly it.
And you don't have to take my word for it. If you write me, and I will send you thousands of pages of historical scholarship about what the First Amendment really protected and how it was supposed to work. But how it was supposed to work is state legislatures set the boundaries of free speech.
Right.
And then the judiciary enforced those boundaries.
Exactly.
And that's how it was supposed to work. And so you would have a patchwork of regulations depending on what community you're in. Seattle probably permits a whole lot more pornography than, Amarillo, Texas, right?
Right.
So be it. That's the nature of a federal system. That's the nature of a system where people get to govern themselves locally.
Yeah, and sometimes it can be messy.
Yes.
And sometimes it results in a patchwork of regulations. Listen, we've seen it with abortion after Dobbs, and that is the function of the strength of representative democracy.
But if you are a transnational pornographical distributor,
Yes.
the last thing on earth that you want is a patchwork of regulations.
Right.
You want one size fits all.
That's it.
And if you can have it, you want it to be supremely libertarian.
That's
right
exactly
now,
it.
they have exactly what they want, which is why they've created their free speech coalition.
Yes.
And why they're going to the Supreme Court, because this is existential for them.
Yeah. Oh, that's exactly it. So, it's interesting because you hear of terminology like community standards. Community standards have evolved significantly from the last time that we received iterations like we did in Miller or in Ginsburg. These are significantly more liberal now than they were in the past. Are you hopeful, or would you like to see the justices do away with language on community standards altogether and simply say, you know what, this is for the people and their elected representatives. You set the boundaries, and we will identify and accurately interpret those boundaries. But as to your ability to legislate on this highly controversial issue in the first place, it's really the purview of representative democracy, not the purview of the judiciary.
So I actually don't think the court will go that way. And let me explain why. If I was sitting in their position, if that was the argument that Texas made, right, the response from the pornographers is, well, surely maybe you don't buy that our pornography is, speech, right? But surely there are artists who are legitimate artists, who I think we'd all agree are sort of legitimate artists, who did things, who created art which at the time violated community mores, right?
Yes.
But which we would now say is truly art and worth protecting, right? They're going to play up that line so that the line becomes huge and sort of terrifying to the justices. And although we sort of make fun of them for being pornographers and they're not really, it's not really free speech, the point that they make is actually a good one, that there's somewhere that they're not near the line, I think. Yeah. But there is a line somewhere. And you do want, the First Amendment does protect some speech which is, to some people, maybe obscene, right? But the point is, at that line, it does get hard. Yeah. And you can't just, the judiciary can't just step back and say, we're not doing this. Right? We saw this in the Murthy case, the censorship case, right?
Yes.
The federal government under Biden came in to the tech companies and said, you better censor all those anti-COVID lockdown people, or, maybe we're going to regulate. And the Supreme Court said, can't touch it, right? You don't want that situation here either.
That's
right? So
true.
Obviously there's a line somewhere, and it's hard to find. I don't think that the Supreme Court is probably going to be willing, maybe Justice Thomas, because he's always one to be like, did we step away from the Constitution 50 years ago? Yes, we got to get back on track. Right. But the other justices don't have his steel spine. So what I think that they will probably do, what I think the best case scenario is for somebody like me in this case who would love Texas to be able to put an age verification law. And mind you, I said a moment ago, this is existential. This is not actually existential. This is just age verification, right? They can still maintain their website. This is just
right. You just have to require age verification, and they've argued that it's chilling their speech.
Actually, they have argued that it is chilling their users' speech.
Their user speech. Actually, that's a great distinction, right?
Actually, chilling their users' ability to see their speech. It's convoluted.
Yes.
But again, because the doctrine is such a mess, that complicated sort of vehicle isn't even challenged. But going back to the point about how the Supreme Court, I think, ought to resolve the case, under current doctrine, you could sort of say, look, the government has a compelling interest. No matter what level of sort of scrutiny, we're going to get in the legal weeds here, but
no. And let's talk about levels of scrutiny, because we've got a First Amendment question, and those types of questions require a high level of judicial review, the highest tier of judicial review, called strict scrutiny. Right? So the state has to demonstrate a compelling interest that is narrowly tailored to achieve that interest and the least restrictive means of doing so.
Yes.
A high bar for any state to achieve.
Right. And that's really the fight in this case. Does the government have a compelling interest in protecting children from the harmful effects of pornography?
Of course. And we would probably argue yes.
And I think that argument can be made pretty well. I think that the Supreme Court has everything it needs to say yes, right? We've got to, but the next question then is age verification either through third parties or credit card companies, is that the narrowly tailored? Is there a better way of reaching that end? And the parties fight about that, as you can imagine, because that's really sort of where the rubber meets the road with respect to the legal doctrine issue. But I think even in that framework, I think that the Supreme Court could say, yes, this still stands up. So you wouldn't actually change any of the court's messy doctrine. You would just say, look, the state definitely has an interest here. States have always had an interest in protecting people from these sorts of harmful effects. We know these harmful effects exist. We're dealing with children, so the concern is amplified. The state's right to intervene is amplified because these aren't adults making free decisions for themselves. And look, it's the same thing as a brick and mortar, adult shop.
Porn store,
it's just, right. It's just, this is the world we live in now. It's the internet. You got to age verify somehow. This is the best way to do it. Credit cards or third-party venues. There isn't really another way.
Yeah.
So, strict scrutiny, you survive anyway. I think that's probably the best case. I think that hoping that the Supreme Court sort of returns the First Amendment jurisprudence to a more constitutionally sound basis is probably hoping too much. But hope springs eternal.
So have there been amicus briefs that have been filed that identify some of these sociological, social, psychological imports of porn on the minor child's developing psyche?
Yes.
And listen, I have 3 kids. Let me tell you, kids are seeing this material younger and younger. To 12, 11, 10 years old sometimes.
Well, a lot of this stuff, if you're just sort of, they call it doom scrolling through Instagram reels, right? You'll see stuff which is maybe not explicitly pornographic, but certainly
right on the line.
Right on the line.
Yes.
And you know how the brain works, particularly if you're a teenage boy, which I was once.
I have 2 of them. I know.
You know how, I don't need to go any further. You know how the male mind works. And so, but to get to your point, yes, there are briefs which go through tons of research from psychologists, and none of this is new. We've known this for a very long time.
Yeah,
pornography does terrible things to the mind.
Yeah.
Particularly to men, although it does very bad things to both men and women's minds, but particularly to men, it changes their conception of what a healthy sexual relationship is. It makes them view women as objects.
Yeah.
It has a really particularly disastrous effect on the way that the mind anticipates sexual gratification.
Yeah.
So a healthy human mind thinks, say, a husband and wife, right? A healthy husband thinks of sex with his wife and yearns for that, right?
Yeah.
A man who's addicted to pornography, the excitement is for the viewing of pornography, and the actual physical intimacy with his wife becomes no longer what spikes the dopamine reaction.
Right.
So you have a perfectly healthy man with a beautiful wife, and he doesn't want to have sex with her because his mind is cued.
Is now cued into that online stimulus.
Correct. Which is going to destroy the man's marriage.
Absolutely.
Let me tell you. So. It's devastating. And if that starts early, much harder for that to be corrected, particularly with a young and developing mind. If that becomes normal in your teens, and then that becomes your norm until you get married in your 20s or 30s, I mean, holy cow.
So one last question for you, GC. I'm curious as to whether you think the element of sort of profitability is going to come into play. And I say that from the standpoint that, again, these are not traditional free speech defenders. It's pornographers, right? That, yes, the Supreme Court's got some very problematic opinions saying, okay, it's got to be really lewd and lascivious and appeal to prurient interest and not have artistic value. And they're building on that foundation. Are we likely to have any argument, and have we seen it in any of the briefing that you've looked at, related to the fact that this is nothing more than at bottom their essentially thinly veiled concern about their bottom line? Because we know it's a $1 billion industry.
Yeah. No, and actually, I don't think we should. And let me explain that. I think that the value that free speech provides, it provides whether or not it's being done for profit or not.
Yeah.
So think about, like, you and I get paid to do this, right?
Right.
So in a sense, we are paid for the speech that we produce.
Yeah.
And I happen to think that the speech I produce is doing some good. At least I'm trying.
Right.
At least that's
As
why
do
I do
I.
it, right?
Yes.
I could still be practicing law. But I chose to do this because I think it does some good.
Yeah.
And so, and a lot of people are like that, right? If you donate to an organization that is somehow public-facing, their business is speech. But they're also trying to do good, right?
Yeah.
And you need to make money, or you can't do it, right?
Right.
So I don't actually want the profit motive to be a distinguishing factor here.
Yeah.
I actually think that if you can make money speaking, you should be able to do so. And I would hope that you would be using that to speak well and to do good.
Yeah.
But that's why I wouldn't want the profit motive to be the determining factor. But let me side note. But what you said about what we were talking about doing good, right, raised something in my mind. The way that free speech regulation was done in the past.
Yeah.
One of the concerns was, well, is this speech doing something good, right? You think of the old cases that upheld blasphemy laws, right?
Yeah.
There was the cases, there's a very famous case from New York, early 1800s called Ruggles. And Ruggles said, or Ruggle, I forget. Email me.
I was just going to say, we won't fact check you.
The facts stand up. The name might not. But it said, look, the legislature has an interest in monitoring the sort of speech, regulating speech which is not conducive to the public health, the public morality.
Yeah.
So the question if this case had been brought, say, 100 years ago, the question would have been, is there good in this speech? Is
Yeah.
it good to be done in this speech? Now, if you were in that framework as a pornographer, you would really play up the idea that, well, look, Michelangelo's David is naked, and you would say,
Yeah.
this artist created nudes and they were scandalous at the time, but now, you play that sort of thing. What's interesting is that there is nobody in this case on the plaintiff's side, the pornographer's side, that will say this is good. The pornographic actress who's proceeding this case is anonymous.
Wow.
They
so it
haven't
doesn't even want to be identified.
Right. They are representing, they're saying, we are defending the free speech rights of our users.
Exactly.
There is not a single user who will stand up with them and say, I will put my name on this and this is good and I want to stand up for it. Nobody will show their face to say this is good, which is immensely telling. It's not legally relevant, unfortunately, right?
But it's morally and I think philosophically telling about the industry itself.
Right. And it's telling about the purpose of free speech, the protection of free speech,
Yeah.
right? You protect it, and you protect even bad speech because you hope that because by protecting even bad speech, the Nazi march through Skokie, right?
Yeah, of course.
By protecting even bad speech, you are promoting the good of speech in general.
Yeah.
But if what you're dealing with is pornography, it's not really speech. There isn't really a good.
Yeah.
It's not like it's defeated with counter speech, right? The Nazis could march in Skokie and then the country...
And then there could be a counter march.
Right. Or even simpler yet, the country saw what they believed and were like, oh, wait, hold on.
That's exactly it.
Right? It was good that the Nazis got to rally so that the rest of the sane people in America could see that and think, okay, that's not something, we're not going to make jokes about World War II, right?
Right,
Like,
right.
we're not going to make jokes about, I don't know.
Yeah, or
Hitler
even the
jokes,
West
right? But-
Virginia versus Barnett case when the
Right.
students wanted to wear black armbands to
Right.
protest the Vietnam War. And that good that was provided was the ability to have an open dialogue about whether or not this war
Yeah.
was good, whether it was valid, whether
Right,
it was, publicly sound. There's always inherently a good, except when it comes to pornography.
Right. And that's why it's good that the Supreme Court all those years ago said obscenity is not protected. But then it became bad when the Supreme Court said, well, we get to define obscenity and one size fits all. The only thing we can do is sort of there is no obscenity, really.
Right. Yeah. Wink,
wink. Yeah, wink, wink. That's the problem. So it's good to have obscenity is not protected, but much thornier is like who gets to decide what obscenity is.
Right.
And now I think state legislatures and local communities should get to do that. But then the question gets hard from the justice's perspective again, right? Because now you've got to, where do they come into the back end, right? Like what kind of, imagine this hypothetical. This is the sort of thing that keeps me up late at night. So the Supreme Court says, okay, obscenity is not protected. And you are a left-wing legislature. Let's go back to Seattle, my favorite punching bag right now. I don't know why I didn't pick, I'm from San Francisco. I should have picked San Francisco. Let's go back to San Francisco. And you're a left-wing legislator in San Francisco, and you say, okay, you know what? I can outlaw hate speech if I call it obscenity. So it is obscene to say, for instance, that I don't know what's some sort of hate speech. Oh, it's obscene to say that men can't become women.
Bingo.
Right. Okay, that's obscene.
Right.
Well, now maybe you and I want the Supreme Court to have some kind of backstop rule, right?
Right.
But drawing that line is really hard. I don't have the answer. I'm not here with the answer to give it to the
and the
Supreme Court.
Court's already said in Madel versus Tam that hate speech is protected,
yes,
right? Because, again, the good being, listen, we want a divergence of opinions represented. We restrict speech in other categories. I think that's important for the listeners and the viewers to understand that there are certain restrictions based on whether it's fighting words or child pornography or speech in furtherance of a criminal activity. We restrict speech. There is not a blanket free speech right without any restrictions whatsoever. The Supreme Court and legislatures have seen fit to kind of whittle away and provide that balance between the public good and constitutional free speech principles. So it's not as if there exists no other regulation or limitation on speech. And so even within this context, and of course you mentioned at the beginning, child pornography is restricted despite the free speech right that exists in the First Amendment.
Right. Well, I think I would say that's not speech, right?
Yeah.
Child pornography is not speech. It's easy to say it there. Why is it harder to say it here?
Bingo.
And the reason what the pornographers would say is, well, it's art. At least some of it is art.
Right.
I mean, probably not.
Yeah.
Probably not.
That doesn't pass the smell test, I think.
But
again, you've got decades and decades of the Supreme Court saying, we know it when we see it, and it's got to be really, really awful for us to say we can restrict it.
Right.
Yeah, I think this is going to be. You have convinced me. I thought it would be much easier.
I wish it was easier. Although, again, some of those questions on the back end do get really hard. Like I am a huge proponent of free speech. Let me not. I don't want to convey the conception.
Am I.
Yeah.
Yes.
I don't happen to think that like hardcore pornography is free speech, and I don't think that that's difficult.
Right.
As a matter of like common sense.
Yeah.
But I do think, I think you would get, particularly in a very polarized environment, and one where like the political left is very hostile to free speech right now, even as a concept, I think you would get gamesmanship.
Yeah.
You're going to have some left-wing legislator come along and say, oh, I can outlaw obscenity? Well, if I get to decide what obscenity is all the speech I don't like.
Bingo. Yes.
Right? And the justices will wisely be worried about that.
Yeah, as they should be.
And so how you craft a line which gives, Texas the ability to protect children and prevents, some lunatic from saying any speech.
In San Francisco,
Right. Well, I mean, but I'm picking on, San Francisco because
we can pick on San Francisco.
Yes, no,
and
that's
I'm
true,
quite certain there are wonderful people there. Perhaps we have some viewers and listeners who are in San Francisco. But let's just say if it follows traditionally far left, uber progressive agendas, right. As we know the state of California does in general, representatives from San Francisco would be willing to manipulate language specifically for that purpose.
Right. So there's the question is who gets to decide, and then what's the line that can't be crossed that the court enforces. And right now the court just basically says the line is everything's go. Right. And because that's really the only line that the court can functionally police from the top down.
Yeah.
Right? So it's tricky. But again, let's step back from sort of the philosophical brink, right, and deal with this particular case. Right, this particular case again is hardcore pornography, right, and age verification, and that's it, right? That's it. Yes, although all these sort of big philosophical questions are raised.
You can still make your porn, Free Speech Coalition.
Right. The case we're dealing with is actually narrow. This is about kids and adults getting access to hardcore pornography. The adults can still do it if they're willing to put their name out there somehow.
Yeah.
And they're not, which is sort of telling.
Interesting.
Right? Again, but that's all that this case really comes down to.
And let me just add, and you know this and I know this, but just as a reminder to people who are listening, we restrict the ability of children to do lots of things, right? We restrict their ability to buy alcohol or buy cigarettes or sign a contract or register for the draft because we recognize, as does the Supreme Court, because they've actually said so in multiple decisions, children lack the maturity, the intelligence, the capability to really fully understand the consequences of their action. They don't automatically, my 15-year-old son is not going to automatically recognize the social science consequences, the philosophical moral import of viewing pornography because he's 15. Right. Okay, there was a point at which he thought he was a firefighter and walked around wearing nothing but firefighter boots, okay? Which was not only messy, it was very awkward. But we don't give children the full functionality for their own good, right? So we restrict their ability to do things in other contexts. But you're right, you've perfectly crystallized the issue. It's pornographers want to keep producing porn, and they want to make sure their users don't have to age verify. And a state wants to legislate in a way that protects kids. And therein lies the clash.
Yeah.
So,
and look, if age verification is such a threat to you because you know, perhaps rightly, that your users won't want to be associated with the product you're producing.
Yeah.
That tells me that what you're producing is probably not speech.
Yeah.
Probably not something of any value. And, in my mind, that weakens your free speech bona fides.
I would think so as well.
Even the Nazis at Skokie, were willing to be there.
Say, I'm a
stand
Nazi,
up and say,
I'm
a
gonna
Nazi
march.
here, listen to what I think,
Yeah.
right? What you're selling is speech, somebody is always they may be a lunatic, but somebody's going to be there with you and endorse what you say and stand up and fight for it. But nobody's got their name on this, which is really interesting.
Well, Giancarlo, I'm assuming you will be listening on Wednesday, the 15th, during oral arguments. And it has been just a joy to talk to you.
Always.
As always. And now we'll have you back maybe to talk about some of those impressions from oral arguments.
Yeah, for sure.
Okay. Thanks for joining us on Case in Point.
Thank you.
Thanks for joining us on this week's edition of Case in Point. We hope you enjoyed yourself, learned something, were possibly entertained, and understand now a little better why the law is important and impactful for you. Be sure to follow us on X at Case in Point Pod and share this podcast with friends of yours, colleagues, or family who could use a little law in their lives. But in the meantime, friends, court is adjourned.